Well, we'd like to welcome you, gentlemen and ladies and gentlemen, to the webinar presented by the Military Interstate Children's Compact Commission, sometimes known as MIC3. This is the fourth of 4 webinars that we have sponsored and have delivered over the last weeks and months, and the purpose is to orient people to the Interstate Compact on educational opportunity for military children. We're very happy that you were able to join us today. My name is Rick Masters, and I'm the General Counsel for the Commission, and I will be your moderator today. We also have with us Rosemary Kreger, who is the Commissioner for the State of Rhode Island and represents Rhode Island on the Commission, and she also serves as our Training and Public Relations Committee Chair. And with the support of her committee, we've been delivering these presentations as well as many other activities in which we engage in this area of public relations and training. And Rosemary, we'd love to have you make a few remarks to us, and glad you're here today.
Thank you, Rick. Once again, I'd like to welcome you to part 4 of the webinars. This webinar, as Rick has said, is part of the work of the PR and Training Committee. The National Office has been a great assistance to us as we develop the series of webinars, so a special thank you to our National Office. This webinar touches on the legal aspects of the compact. Attorney Masters has guided us through the legal side of the work of the Commission since the inception of the MIC3 compact. He is very knowledgeable about compacts in general. He is thoughtful about how the compact applies to our military families, and he's responsive to the state commissioners on many, many issues that we deal with and maneuver through these processes. So I also want to thank him. So I'll turn it back to you, Rick, and we'll proceed with the slides. Thank you.
Hey, thank you, Rosemary. And as we begin to work our way through this process, we want to welcome questions. However, in order to make certain that all of the information has been communicated to you, we've decided with some debate about it that it would be best to leave questions to the end. However, there is a protocol for submitting questions, and we certainly want to give you time to ask questions. And so I'm going to ask Richard Pryor here with our National Office, who is also on the line, to give you some housekeeping details, so-called, about how to interact with us and how to make your questions known.
Thanks very much, Rick. As you can see, on the left of your screen is the viewer through which you can view the presentation. To the right of your screen is the GoToWebinar control panel, where you can raise your hand, ask questions, and select the audio mode. You should note the control panel will collapse automatically when not in use. To keep it open, though, attendees can click the View menu and uncheck Auto Hide Control Panel. Next slide, please. In the event you wish to ask a question, you can do so by clicking the hand, which you can see on the right. The question may be answered at the appropriate time, and as Rick's just mentioned, that will probably be at the end. I, however, will monitor the questions as they come through. If we have time to answer them all, we will. In the event there is not time to answer all your questions, though, please be assured that we will submit a response post the meeting. Thanks, Rick.
Thank you, Richard. And as Rosemary mentioned, I have had quite a bit of experience in the field of interstate compacts, and we're under the impression, based on the sign-up sheet today, that we have a larger number of lawyers than in these other seminars, and that's by design, because obviously we're talking about legal principles governing the compact, as well as how those principles apply in the context of this particular compact. But I've had the opportunity over the last 20 years to work with not only this compact commission, but several other compact commissions, 3 of which, including this one, have all 50 states as members. And in that process have also done quite a bit of research, writing, and speaking to state legislative committees and other stakeholders about how these mechanisms operate. Have also written a treatise on the law of interstate compacts, which was published by the American Bar Association in 2007. In fact, our editors at the American Bar Association tell us that our sales are right up there with the Amish phone directory. A little feeble attempt at humor there. But seriously, if you do need to know something about this instrument or compacts in general, there is some written material out there, including this treatise on compact law. Many times when I'm talking to lawyers, judges, and other persons with legal backgrounds, I will ask the question, how many of you recall having any instruction concerning interstate compacts when you were in law school or in constitutional law class, what have you? And seldom do I ever have a hand go up. And the reason for that, of course, is that this subject is really not discussed much, if at all, in our legal training as lawyers. In fact, most of what I know about compacts was learned long after law school. If you'd have asked me what is an interstate compact when I was a first-year law student, I probably would have told you it was a Japanese import that one uses to drive from state to state. Who knew that there is actually a clause in the Constitution that governs these instruments and is the foundation for their use? And that's where we want to start our discussion today. In fact, in Article 1, Section 10, Clause 3 of our Constitution, sometimes referred to as the Compact Clause, the words that are on this slide appear that no state shall, without the consent of Congress, enter into any agreement or compact with another state. Now, students of the English language, I think, would agree that that sounds like or reads like all compacts are required to have the consent of Congress. But as it has done in other decisions, the U.S. Supreme Court has redefined the English language for purposes of the Compact Clause and has told us that any agreement does not mean all agreements or compacts, and that only those compacts that would infringe upon some enumerated power that is reserved to the federal government require the consent of Congress. There are many cases in which that doctrine is set forth. One of the leading cases on that principle is on this slide, U.S. Steel Corporation versus the Multi-State Tax Commission. However, the important point, beyond the fact that not all compacts require consent, is that from the beginning of our country, when the Constitution was ratified in 1789, our founding fathers have provided a mechanism for states to govern various types of activities in our country by marshaling their collective sovereignty in a way that the federal government is not needed but can still achieve uniformity. And that's really the purpose of interstate compacts, including the compact that we're here to talk about today, the Interstate Compact for Educational Opportunity for Military Children. The other thing I want to emphasize with respect to compacts is that this is not the only one. In fact, there are over 200 interstate compacts that have been formed since the founding of our country, and on average, every state is a member of or has enacted approximately 24 compacts. We are proud that our compact is one of those few. In fact, there have only been 4 compacts in the last 60 years that have been enacted in all 50 states, and we are pleased that our compact is one of those. However, the idea of regulating through collective exercise of sovereignty by the states is not a new concept. And in fact, in 1921, the first example of a compact which was formed to engage in regulatory activity is served by the Port Authority of New York and New Jersey, which is the compact that regulates all forms of public transportation in the New York, New Jersey region. That would include subways, buses, aircraft, ferry boats, any public conveyance between those 2 states is carried on and administered by an interstate compact entity. This is also the entity that owns the site where the World Trade Centers were formerly located. They have a multi-billion-dollar budget and their own police force. So as you can see, compacts that engage in regulatory activities are certainly not new either. Since compacts have originated with the founding of the country and were initially used for boundary disputes, obviously the concept is one that follows our history as a republic. But over that period of time, compacts have been used increasingly for other activities, including regulation of interstate matters that the states have traditionally had control over. Compacts don't have to be national in the sense of all 50 states being members. We have some, such as boundary compacts, that are simply bi-state compacts. We have regional compacts that regulate activities within a certain region of the country for certain purposes. And then we have compacts such as the Interstate Compact for Educational Opportunity for Military Children that serve the national interest of all 50 states and have been enacted by them. The magic, if you will, legally speaking, of compacts is that they are both contractual and statutory, and they combine the attributes of both. And like any other type of contract, they are entered into by parties who wish to conduct an activity on a consistent basis. But in this case, the parties are the states themselves rather than commercial entities or individuals. Compacts regulate all sorts of activities besides education. Anytime that you have activities across state lines that involve transportation, environment, taxation, emergency management, health matters, corrections, public safety, anything that occurs or recurs on an ongoing basis and needs to be regulated on an interstate basis, but is an area that has primarily been within state jurisdiction, is a candidate for interstate compacts. In fact, there are other compacts that you may have heard of besides the New York-New Jersey Port Authority Compact. For instance, the Colorado River Compact, regulating the river basin through which the Colorado River flows. That's an example of many other such compacts that are formed to govern natural resources, such as river basins, gorges, canyons, and other public lands. There's the Interstate Compact on the Placement of Children, which regulates the transfer of wards of the state, or in some cases adoptions, across state lines. If you've ever flown into the District of Columbia in Washington, D.C. to do business or to visit, you may have done as I frequently do, get off the airplane and hop on the metro to find a cheap and economical and efficient way to get downtown. And if you've done that, you were riding on a conveyance that is under the control of yet another interstate compact called the Washington Metropolitan Transit Authority Compact. So as you can see, these are increasingly and commonly used for regulatory purposes, and that is developing into the 21st century as it has during the 20th. So in summary of this portion of our presentation, we can point out that compacts are used for three primary purposes. First, they continue to be used for resolving boundary disputes, just as they were between the original 13 colonies. They are used to institutionalize and manage interstate issues pertaining to allocation of natural resources, as I said, such as river basins, gorges, canyons, etc. And most importantly, compacts are increasingly being used for ongoing administrative regulation, including the creation of interstate administrative agencies that have jurisdiction over a wide variety of concerns, including education. And you see on the slide other examples that we've mentioned. So once again, let's talk for a minute about the legal aspects of these instruments and how they are analyzed for purposes of interpretation and application. As I said, compacts have the characteristics of both statutes and contracts, and like any other contract, the language must be sufficiently similar in order to indicate a meeting of the minds and that the parties to the contract and interstate compact statute have all agreed to the same substantive means of accomplishing the objectives of the compact. So therefore, the first state to enact a compact is in essence making an offer to every other state to enact that agreement in a way that shows that subsequent state's intention to be bound by that agreement. For that reason, language of interstate compacts, unlike other types of statutes, needs to be substantially similar, not necessarily identical in every word and punctuation mark, but sufficiently similar in all of their operational details, again, to indicate that the states that have enacted the compact statute intend to be bound by it. Once enacted by 2 or more states, a compact, like any other contractual agreement, which has been authorized under the compact clause, in other words, states are free to do this, sometimes with consent of Congress, other times it's not necessary, but the other constitutional protection for these instruments, which also makes them enforceable, is the contract clause of the Constitution, which protects contracts from impairment by the states, including contracts that the states themselves have entered into. For that reason, a compact cannot be impaired by a state which might want to enact or might have actually enacted a conflicting statute or rule. So while a state cannot be bound to a compact which it has not enacted, once it has adopted the compact therefore takes precedence over conflicting statutes of a state because of its contractual nature and because of the contract clause of the federal Constitution. A state therefore cannot unilaterally nullify, revoke, or amend a compact unless the compact provides that that can be done and must adhere to the statute provisions regarding any of those steps in order to effectively nullify, revoke, or amend one of its compacts. So you might be asking at this point, what difference does it make if congressional consent has been granted or has not been granted? With respect to Article 1, Section 10, Clause 3, the Compact Clause, we've already discussed the fact that the Supreme Court's taught us that not all compacts require consent unless they infringe upon some enumerated federal power. What difference does it make if consent has been granted? The difference primarily is this. If Congress is needed with respect to granting consent to a compact, there is a transformative effect that occurs when that consent is granted by Congress, and the Supreme Court says that such a compact has been transformed into the equivalent of federal law, which makes the Supremacy Clause very relevant for interpretation and application of the compact, because obviously it would then take precedence over conflicting state laws or regulations because of the Supremacy Clause. And it also adds to the arsenal of enforcement tools for a compact with consent, because it's enforceable then not only under the Contract Clause but also under the Supremacy Clause. Notwithstanding the fact that a compact has consent of Congress, it still remains subject to the control of the states that make it up. And it's really the only example in our legal system that I can think of where state officials who are engaging in rulemaking, for example, on behalf of a compact commission that has received the consent of Congress, are actually creating the equivalent of federal law. State officials making federal law. Quite a unique device in our Constitution. So, what if the compact does not have consent? Once again, under the Contract Clause, states still are not free to impair that obligation by enacting conflicting statutes or conflicting regulations, and so therefore the language of the compact, even if it is not required to have consent, would take precedence over those conflicting laws, and enforcement can be taken with respect to the contractual aspect of the compact. The compact that we're here to discuss today also has rulemaking power, and this is not uncommon either. Commission rules under the Interstate Compact for Educational Opportunity for Military Children are required to be adopted in the manner that is substantially based upon the Model State Administrative Procedures Act. Once these rules are adopted, they have the force and effect of statutory law and will supersede inconsistent state laws because of the Contract Clause. And the Compact Commission that the MIC3 Compact has been created to carry out has been delegated authority by the states to engage in rulemaking. That process has all of the above referenced limitations that are contained in the Model State Administrative Procedures Act, and a majority of state legislatures are authorized to reject a proposed rule. The Supreme Court has spoken on this issue as well, and as long ago as 1951 has held that a state legislature's ability to delegate regulatory authority to an administrative agency, including one that's created by an interstate compact, is, as former Justice Frankfurter said, one of the axioms of modern government. The Commission does have the authority under the statute to enforce the compact as well as its rules, and like any other administrative agency, the philosophy of the Interstate Commission for Educational Opportunity for Military Children is to use as little coercion as is necessary in order to achieve the purposes of the compact. And by coercion, I mean legal remedies to enforce the compact. And so frequently, we simply need to turn to the lack of knowledge of individuals who are charged with implementing and accomplishing the objectives of the compact. And ignorance is our biggest enemy. That's probably true throughout education, and thankfully ignorance can be cured. And we do that through remedial training and technical assistance. We do that through public relations and training seminars such as the one you're listening to now. And in many cases, that is the cure for the disease. However, we must acknowledge that there are times when reasonable minds differ, and so there are occasions when states may have legitimate disagreements over the application or interpretation of the compact. The compact contains alternative dispute resolution mechanisms, including mediation and arbitration, that can be used to resolve those disputes. If there is a pattern of deliberate and what appears to be willful noncompliance with the compact by a state, there are more punitive sanctions that are authorized under the compact language, including imposition of monetary fines and ultimately seeking relief in federal court. And the type of relief we're talking about is not some huge lawsuit for millions of dollars. It's primarily a petition for injunctive relief where we're asking the court to enforce this contractual agreement, which has been enacted by statute, and simply require the parties to keep the promises that they've made when the state enacted the compact. Those kinds of legal proceedings are rare, but have occurred in the context of several of the compacts which I have advised and represented, including this one, but it certainly is the last resort and only when all other alternatives have failed and is necessary to enforce the validity of the compact. So I think you can see why it's important, certainly for lawyers who are at this seminar, as well as other officials who are involved in the implementation of this compact, to be aware of the statutory language in your state. As I said earlier, we're pleased that all 50 states and the District of Columbia have enacted the compact statute, and you certainly can find that within your statutory code. We certainly have listing of those statutory citations if you need assistance in finding that, although I'm sure there's no lawyer on the call that doesn't have access to Westlaw or LexisNexis or even a computer research service of another type to find the statute. Hopefully you've already had an opportunity to read it. Certainly it's not exactly a recreational experience, but very important for you to do so. Certainly all commissioners of our states, of all 50 states, need to be familiar with the language as well, and we hope their legal advisors are equally knowledgeable when questions come up in your state. Briefly, and without drilling down too deeply into the substance of the compact, I want to recommend that you read it and consider it, but primarily the compact has substantive provisions in 4 different articles that are directed toward the problems that military families encounter as they transition from one state public school district to another. And this is based on some exhaustive studies that were commissioned by the Department of Defense before the compact was ever drafted, showing that most of the time the problems that military families will experience when their kids in grades K through 12 move from one school district to another will be in one of these four categories. The first one is covered in Article 4 of the compact, involving enrollment. This has to do with such things as the transfer of educational records and immunizations and entrance age requirements for kindergarten when those issues arise as a family transitions from one state to another. For instance, in many cases, the move is necessitated because the Department of Defense has issued orders to the family that's been put on active duty or deployed, and they are required to move in a very short period of time and may not have been able to get the certified copy of the transcript of the student who needs to enroll in the public school district of a new state that the family has moved to. Instead of delaying enrollment, the compact, for example, in that case, would require that the receiving school district go ahead and process the enrollment based on a photocopy or whatever record that the family has been able to secure and provide on an informal basis, and then the sending state school district is responsible for sending the certified documents within 10 days. Another example is in Article 5 in the area of placement and attendance. Frequent problems are encountered by students who are transferring from one school district to another when mom and dad are ordered by the DOD to do so. And so they will encounter difficulties with regard to whether credits are given for courses that have been taken, issues relating to end-of-course exams, issues relating to special education programs that were in effect in the prior state, and such things as absences related to deployment. The placement and attendance issue would involve certain obligations on behalf of the receiving state as well as the sending state. Under the compact, the receiving state is required to respect the placement decision that has been made in the sending state and to initially place the student in the same level that the student was in or in the next grade level for the next year as would have been done in the sending state. But the receiving state is allowed and certainly not in any way restrained or prohibited from doing appropriate testing after the student has already enrolled and been placed to determine if that placement is in fact appropriate or if there's some adjustment that's necessary. We're certainly not trying to disturb the quality of the education, only that we ensure that the students are progressing and moving forward in their academic programs to secure on-time graduation. Article 6 deals with the area of eligibility. This is in regard to such things as extracurricular activities, including such things as perhaps the student, for example, has a 4-point average but arrived at the new school district too late to attend the candlelight induction ceremony for the Beta Club or the National Honor Society. Under the compact, we ask that the receiving district accommodate the student and allow them to participate in that extracurricular activity if they are otherwise qualified. So in my example, if you had the 4-point average, you obviously were qualified. Just because you missed the induction ceremony shouldn't prohibit you from being able to take part in that extracurricular activity. And then finally, with graduation, as said previously, we certainly want to make sure that students of military families are making progress and are being educated in a proper manner, but we also know, as all of you, I'm sure, if you work with school systems, know that it's important for a student to graduate on time. And so we ask states to be as accommodating as is possible and as flexible as possible without endangering the education needs of the student to ensure on-time graduation by giving course credits wherever possible for equivalencies between states, waiving end-of-course exams if there's another means of properly determining that the student has the adequate knowledge to receive the diploma. We ask for any exams that are required under the state law for graduation requirements to be respected in the form of some alternate test if if possible, if they took such a test in the prior state. And if all else fails and no other accommodations are possible, we ask the receiving state to work with the sending state to ensure the receipt of a diploma if the student's work in the prior state would qualify the student to do so. And Article 8 here on the screen provides for state coordination, which I'll talk about in a few minutes. Under Article, well, in fact, we'll talk about it now. Under Article 8, we have institutionalized the function of the commission within each state through the auspices of what is referred to as the state council. Under the statute, as you'll see when you read it or if you've read it already, each state appoints a commissioner to represent that state's interest on the National Commission and meets at least once a year face-to-face in an annual meeting, and more frequently for committee responsibilities and ongoing responsibilities under the compact by electronic means such as teleconference, as we're having today, in order to effectively represent the interest of your state on the commission. In addition, to support that commissioner, there is a state council with regard to the Interstate Compact for Educational Opportunity for Military Children that's responsible to be backing up the commissioner and talking to the commissioner and communicating issues of concern in that particular state with regard to the compact, particular areas that individual school districts or school systems or groups of school administrators may have with respect to particular problems under the compact and transitional issues of military kids. And it's a way for recurrent and regular communication to occur between each state and the National Commission with regard to things that may need to be done or adjusted or handled in particular ways. That commission, that council in your state is a very important body and includes not only representatives of military installations, but stakeholders from the education departments, representatives from both the executive and legislative branches, and others that you, in your wisdom, believe ought to be on this council in order to effectively communicate and disseminate information about the compact through the school system and among the various stakeholders. The commission has a national office. We are a lean and mean organization and intend to stay that way. We have an executive director. We have myself as general counsel, and I serve on a contract basis, so I don't have a lot of overhead costs and other expenses of a full-time employee. We also have some full-time specialists, including John Matthews as our program specialist and Richard Pryor, our operations coordinator, to facilitate and administer the activities that the commission is engaged in and to be responsive to the needs of the commissioners with respect to their ongoing responsibilities and duties under the compact. Our primary job as the national office is to serve the commission and only to assist in those goals and objectives that the commission has set for itself under the laws, the statute, and the rules that have been adopted by the commission. We also provide, obviously, logistical support, such as that's being furnished today for this web conference, as well as support for both electronic committee meetings and on-site meetings and trainings which occur. Certainly, that would include information and training that you may need or want in your state, whether it's for state education lawyers, state school administrators, and other stakeholders. We can put something together with you, either electronically or on-site in-person training or both, and certainly invite you to contact the national office if you have a need for that or have an interest in that. We also serve as a clearinghouse to the commission. There are a number of documents, many of which are located online at our website, which we'll provide to you at the end, in which you can obtain copies of compact statute, rules, a brochure, or a number of brochures directed to various stakeholder groups concerning the functioning of the commission and the purpose of the commission. Also available are meeting minutes, legal documents such as advisory opinions that can be requested by member states concerning the interpretation and application of the compact provisions, and other matters that you may need to bring to our attention concerning ongoing activities and problems that may arise in trying to accommodate the needs of military families. No legal presentation would be complete without some comment about liability, and as is the case with other governmental activities, there are times when that needs to be considered. In a gross oversimplification, let me just say that like other governmental activities, generally administering the compact and carrying out its objectives and purposes will probably not get you sued in areas where discretion is allowed. And in many provisions under the compact, there is some amount of discretion, certainly, which is dependent upon the good judgment of the official involved. And as all of you, I'm sure, know and understand, a discretionary act for legal purposes is one in which a state employee has more than one choice which is legally permissible and makes that judgment based on the best information available to them. Even if that decision later, with 20/20 hindsight, proves to have been wrong, most of the time that's not going to lead to legal liability because you made the best judgment you could under the circumstances and had the legal authority to make a choice. The other type of act which is more problematic is a ministerial act that is commanded by the statute or the regulation, and when the law says you shall do this or you must do that and you have failed to do it, obviously that's a situation where liability could arise. On the other hand, I have some good news for those of you involved in the implementation, application, and enforcement of the compact in your state. There is no private right of action that is created by the compact statute for an individual student or military family. In fact, Article 9, subsection J of the compact clarifies that the compact shall not be construed to create a private right of action against the Interstate Commission or any member state. Further, Article 11D limits the liability of commissioners for the Compact Commission and other agents and employees to that of other state officials, employees, and agents. In other words, if you have sovereign immunity in the particular state where the allegations arise that protects you, that same level of protection is available to you for any activities that are carried out under the auspices of the Interstate Compact for Educational Opportunity for Military Children. There's also some case law out there that's positive and helpful for those of you who are lawyers that must advise your state officials in the education arena about possible liability. And these two cases are Circuit Court of Appeals cases in the federal system, which have made it clear that an interstate compact does not create a federally enforceable right under the so-called Civil Rights Act, 42 U.S.C. Section 1983, for those who are subject to its provisions. So, in other words, individual students or family members don't have a federally enforceable right under the Civil Rights Act to bring a case either. And there's two of the decisions that have reiterated that principle, which are also premised on some earlier Supreme Court cases that are decided and mentioned in those two cases. I'm sure that some questions have come in, or I'm assuming that there have been, and we certainly have 10 or 15 minutes to do so. I'm going to ask Richard Pryor, based on the earlier instructions that he gave us, to tell us what questions have come in, and we'll do our best to answer them in the time we have left. Richard?
Yeah, sorry, Rick. There's actually only a couple that have come in. The first one was somebody asked if they can contact you direct for legal advice if they have issues within their state regarding children.
Yes, they can, and I was going to ask if we have a contact slide. I thought we did. Hang on just a minute. Yes. if you will contact me by email, so I'll have a record of it, I would appreciate it. And you can reach me at rmasters@csg.org. If you do wish to call me, since this is a discrete group, I will certainly offer you my direct line, which is area code 502-262-5881, and I will more than likely direct you back to either your commissioner or the national office if there is some additional step that needs to be followed, but I'm certainly available to discuss any of these points offline. And here we have the commission website, which I mentioned earlier. www.mic3.net is our website, where you will find a host of documents, legal and otherwise, pertaining to the compact, and I think it will be a very helpful resource for you. We also have numbers available where you can reach General Steve Hogan, who is our executive director, who has a distinguished military career as well as a background in education, and certainly he will be available in the appropriate cases to talk with you, as will John Matthews and Richard Pryor. Other questions, Richard?
Thanks, Rick. Somebody mentioned regarding membership, and they're aware you touched on it during your presentation, but with the smaller states, is it easy for them to decide that if after a year or two that it's not actually worth their while to become a member? Can they just leave?
Any state is free to leave the compact in the same way that it entered the compact, and that is by legislative action. It was enacted in the same way that other statutes are enacted, by both chambers approving it and signature by the governor. Repeal of the compact would be done in the same manner. We hope that all states find that the benefits and advantages to military families are such that that step doesn't happen, but certainly, yes, any state that entered was free to do so and is free to leave if they feel that's best.
And that's actually all we have, Rick, just the two questions.
Well, I want to thank all of you for taking time out of your busy schedules to be with us today, and please feel free to contact us offline if you have any questions or comments, and hope all of you have a wonderful weekend. Take care.
Thank you, Rick.